before this first word is even spoken in court, understand what's really at stake here. This isn't just about misrent. This is a collision between strict legal procedure, human circumstance, and the unforgiving clock of landlord-tenant law. A tenant accused of owing $1,700 a month, 2 months behind, facing eviction. A landlord claiming proper notice. And a judge who's about to draw a very sharp line between not getting a letter and refusing to accept one. What makes this case fascinating is how it turns on technical compliance. Certified mail, delivery attempts, notice periods, and the difference between possession and money owed. The tenant walks in swinging hard with accusations of perjury, citing statutes and appellate cases, trying to dismantle the landlord's case piece by piece. But the court is about to remind everyone that eviction court isn't about punishment. It's about possession. So here's the real question you should be asking as we go in. When the law says notice is presumed delivered, does personal hardship change legal reality? And when someone has already moved out, does an eviction even still exist? Let's watch how this unfolds, because the ruling at the end flips the power dynamic completely.
Ms. Harnash, why is this eviction being sought?
Non-payment of rent.
Non-payment. All right. And under the agreement, how much is there a monthly rent?
Yes, ma'am.
How much is that?
$1,700 a month.
Is there any subsidy from the government?
No.
What months are paid or unpaid?
July and August.
Was this a CARES property?
I'm sorry?
Is
No.
this a CARES property?
No, Your Honor.
Okay. And what day and how did you provide the notice to vacate?
I provided the notice to vacate certified mail, and I also sent it to her. I also went over and I told her that I served the notice. She was in her car, and I told her that I served the notice to notice to vacate. And then she said, "Oh yeah, there's a notice in my mailbox, but I haven't went and retrieved it."
All right. What day did you mail it?
I believe it was the let me get it right. I'm so sorry. July 15th.
Good morning, Ms. Crosby.
Good morning, Your Honor.
Ms. Harnash is here. She says she's on behalf of the landlord and that this case is a financial situation. She said that under the lease, the monthly rent is $1,700. Is that correct?
Yes, Your Honor, that is correct.
Okay. And then she said rent has been unpaid for July and now August. Is that correct?
Your Honor, before we continue with the merits of this case, may I present to the court perjury by the plaintiff in this case? Your Honor, the plaintiff has committed perjury in this case. In her
What did she lie about?
I'm sorry?
What did she lie about? What she just told me? What's wrong?
In her sworn petition, she claimed that she delivered a 3-day notice to vacate on July 15th by certified mail. Yes, ma'am. And I have the proof. If you would look at Exhibit A and Exhibit B as in boy, Exhibit A shows her petition where she wrote that she did deliver it by certified mail on July 15th, 2025. Exhibit B shows that there was an attempt made. So this is the slip from the USPS tracking. It shows that the attempt was made on July 17th of 2025. No delivery was successful. It marks here, no secure location available, no authorized recipient available, and signature was required in this case, Your Honor. Her verbally telling me she sent something does not count for an actual delivery.
So you got a notice that you had a certified mail and didn't go get it?
I didn't say certified mail. It said
you just told me that it said required a signature. So you had a notice that you had a letter that needed your signature and you didn't go get it?
Yes, ma'am.
That doesn't count as her not delivering it to you. That counts as you refusing to accept it.
Well, I did. The reason why, Your Honor, during that time I was ill.
I understand why, but that doesn't change the fact that she did what she was supposed to. Your failure to pick it up doesn't mean she didn't reach it to you.
Yes, ma'am, Your Honor.
All right.
This is where the case pivots from emotional argument to pure legal mechanics. The tenant is trying to win on a technicality, arguing that because she never physically signed for certified mail, legal delivery never occurred. She even cites Texas Property Code 24.005 and appellate cases to support the idea that notice runs from actual receipt, not mailing. On paper, that sounds strong, but the judge cut straight through it with the mailbox rule and presumption of delivery. Here's the key legal reality. When certified mail is attempted and the recipient is notified but chooses not to retrieve it, the law treats that as constructive delivery. In other words, you can't defeat service by simply not opening the door. The court isn't weighing whether the tenant was sick, busy, or confused. It's weighing whether the landlord followed the required procedure. And the judge finds that she did. This moment exposes a tension between strict statutory interpretation and common sense judicial reasoning. Was the notice technically perfect? Maybe debatable. Was it legally sufficient? According to this court, yes. And that sets the stage for the real twist that's coming. Because suddenly, the fight over notice becomes almost irrelevant.
Code 24. I'm sorry, ma'am, I can't hear you.
What other parts did you say she was perjuring?
Okay. Under Property Code 24.005, it states that the notice period begins the day the notice was delivered and not mailed, Your Honor. The plaintiff used certified mail only, which requires a signature. She does not have a receipt showing my signature or any delivery.
That's because you admitted you didn't go get it. That's what you just told me.
Yes, ma'am.
You had the notice, but you were busy. You had other things, and as a result, you couldn't do it.
Yes, ma'am. They sent a notice saying that they attempted to deliver, but no delivery was made. There was just an attempt.
I know. We all agree on that. You just told yourself that that's what happened.
Yes, ma'am.
Okay. But you
also,
she was telling you the letter.
I'm sorry. Yes, it does say that if the attempt was made, but it was made on 7/17. She says that she sent it on 7/15, Your Honor.
That's
which is
reasonable. The mailbox rule under the law says 3 days is presumed before delivery occurs. It sounds like you got there on day 2.
Okay.
If she mailed it on the 15th and they were trying to get it to you on the 17th, that's 1 day faster than the law assumes.
Okay. Well, I was looking at Texas Property Code 24.005, which states that the delivery begins the notice period begins the day the delivery is made and not mailed.
That's correct. So, Ms. Crosby, you're absolutely right. The rule, though, about when something has been mailed as delivered is 3 days. So if I mail it on the 1st, the law presumes that it's been delivered in 3 days. Here, you just acknowledged and testified that you got it on the 17th, the notice to you, you just didn't have a time. You had other things that you didn't go pick it up. But indeed, it got to you within 2 days of her mailing it.
Yeah, there does say a certified mail slip, but it doesn't tell me that it's hers. I didn't know what it was, Your Honor. Also here, I did cite 2 cases, Gore versus Homecomings Financial Network, and also Kennedy versus Andover Place Apartments, where the Texas courts, the appellate courts made a clear, strict compliance mandatory of the 3-day notice and states that the 3-day notice is upon delivery and not mailing. The actual person has to receive it. Your Honor, she also did not, she could have also sent it, she could have sent it by mail, by regular mail as well as certified mail, which she did not, to make sure that it was delivered to me. Yes, ma'am. This possession for filing, Your Honor, I would like to bring to your attention that this case was brought to an eviction court purely for monetary gain. There was never an eviction in place, Your Honor, because I had already moved out by the time she filed.
Have you moved out of the unit?
I moved out August 4th.
Have you returned the keys?
On August 4th.
Ms. Harnish, is that correct?
She left the keys underneath the mat.
So she moved out and gave you the keys back?
She left the keys underneath the mat.
She moved out, you got possession. You can sue her for the money that she owes, but she moved out, she gave you the keys back, you got what you wanted back. Judgment for the defendant. You can appeal me, Ms. Harnish. I'll put it down at $500. Okay?
Your Honor, one more thing, please.
Ms. Crosby.
Ma'am? I know, yes, ma'am.
Okay.
But the plaintiff is also holding third-party property that belongs to Appliance Warehouse. Your Honor, I'm begging the court to please direct her to release that property.
I can't. That's called injunctive relief, and I don't have that authority as a justice of the peace.
Okay.
Please contact the law library for how you might pursue that. But for the eviction, which is something that is relevant to this court, You moved out and you gave her the keys back. Ms. Harnish has the right for 4 years to pursue you for the money that hasn't been paid, if indeed that's true. But in terms of possession, she's received that back, and that's ultimately the goal of the eviction court. Okay?
Yes, ma'am.
All right, ladies, y'all have a good afternoon. All parties are excused.
Thank you.
Either one can appeal me. It'll be $500.
Thank you.
What was the judgment for?
Judgment for the defendant. So there's a nothing for the plaintiff. Because she moved out, you got possession back.
Okay.
If you want to pursue her for the money she owes, you have 4 years under a breach of contract case for that.
Okay.
And Ms. Crosby, be aware, she can sue you again, or the landlord, it's not Ms. Harnish, whoever the landlord is, can try to pursue you for the money and any damages, security, any of those things that remained from it. An eviction is about getting possession back. If you moved out and gave her the keys, then she doesn't need an eviction. What she needs is monetary compensation, and that's something y'all can both pursue independently. All right?
The final ruling lands with a legal mic drop, judgment for the defendant. Not because the rent wasn't owed, not because the notice failed, but because the purpose of eviction no longer exists. Eviction court is about possession, and possession has already been returned. The tenant moved out. The keys were surrendered. The landlord has the property back. Case closed. What this court makes crystal clear is the separation between two legal paths, eviction and debt collection. The landlord may still pursue unpaid rent damages and contractual obligations in a separate civil suit, with up to 4 years to do so, but this courtroom's jurisdiction ends the moment possession is restored. No injunctions, no property disputes, no leverage through eviction once the unit is vacated. It's a powerful lesson in how procedure, timing, and jurisdiction shape outcomes just as much as facts. So what do you think? Should a tenant who owes rent but moves out escape the eviction process entirely? Or did the judge apply the law exactly as written? If you found this case as shocking and eye-opening as we did, make sure to hit that like button. Share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.
Yes, do I do it in your court?
If it is under $20,000, then yes, this would be an appropriate forum for it. If it arose out of our precinct and the lease, you could do it here. You also have a choice, Ms. Harnish. This is true for any lawsuit. You can either sue where the action accrued. So if it was a lease that happened in this precinct, this would be appropriate. You can sue in the precinct where the defendant resides. So if Ms. Crosby's moved and she's someplace else, you can choose to sue her there. It is the plaintiff's choice about which of those two forums they want.
Well, I don't have an address for her. She told me good luck finding out where she is.
No, ma'am. You have the address. The court has the address. Yes, ma'am.
Ladies, I'm not trying to have y'all dispute with each other here. I'm going to say that there is a way to sue someone even if you don't have their address. It's called alternative service. Look into that as well. Okay? Y'all have a good day. All parties are excused. Thank you.